first thing on the agenda is a continued public hearing on 1041. I'm not even sure what to call it. I want to let John explain to us.
Well, it's our proposed resolution on the designation of Phil's World Trail System as an area and activity of state interest pursuant to CRS 2465.1, 401, and the statutes that follow that. Hopefully we can put it up.
To do the,
Oh yeah, go ahead and read.
you need to read the public notice.
Oh.
Call the roll.
Sure.
You're right.
The Montezuma County Board of County Commissioners will hold a public hearing for the purpose of reviewing and determining a CRS 24-65 1-101 designation consisting of properties which make up the Phil's World Trail system located 2 miles more or less east of Cortez, Colorado, consisting of 730 acres more or less of state-owned leased property and 2,400 acres more or less of Bureau of Land Management situated in sections 3, 4, 9, 10, 11, 14, 15, 21, 22, 23, 26, 27, and 28. Township 36, range 15 NMPM. The hearing will be held Monday, January 11th at 2016 at 1:30 p.m. Was continued to Monday, February 22nd at 1:30. Commissioners Hearing Room, Montezuma County District Courthouse, 109 West Main, Cortez, Colorado. Interested persons may attend and give input. Information may be obtained from the Planning Office, Room 305, District Courthouse, Cortez, Colorado. Accessed online at http://montezumacounty.org, Web Departments Planning, or by contacting the Planning Department at 970-565-2801 with questions. The file can be inspected in the Planning Department during regular office hours. Dated this first day of December 2015, Kim Purcell, Clerk Board of the County Commissioners, Montezuma County, Colorado. Published in the Cortez Journal on Friday, December 4th, 2015. And I forgot to call the roll, sorry. Commissioner Supla is absent. Commissioner Lambert?
Here.
Commissioner Attell?
Present.
Administrator Bruner? Here. Attorney Baxter?
Here.
And Kim Purcell, Montezuma County Clerk and Recorder.
So, this is the same document that was published on our website, except for Ms. McAfee was nice enough to point out that 2 of the statute numbers were wrong after the decimal. So that's the only thing I think that's changed on the document that's being shown right now. We can modify it and change it according to how you all want to today after you hear public comment. And maybe we should do public comment first. I mean, essentially what this is on land, which is U.S. land and state land. The county doesn't own this land, but it's this law allows us to make it more burdensome to develop and have more control over that land. So what this resolution proposes is to, if there is anybody who wants to try to develop there, they would also have to go through the county, the planning department. They'd have to fill out a permit application, basically a high impact permit, and go through our rules as well as either the state's or the U.S.'s. If it's on state land, this resolution also requires them to meet the U.S. requirements. And maybe we can try to answer questions after we hear public comment, more public comment. I know everybody had an opportunity before. Does that explain it well enough, or did you have anything else you wanted me to say?
Not explain. That we have 30 days to approve this.
Yep, the law allows us to to change it after we we can make modifications after today. To not adopt it at all, you all can choose not to. Larry Don Sukla, one of the commissioners who's not here, this might have originated from his idea. I'm not positive about that, but I think it might have. And I think the commissioners might want to, I know James had mentioned to me, consulting with Larry Don about whether or not to approve it or not. So you all don't have to vote on it today. You can wait, and you have to do it within the next 30 days, or or we do this again and have another hearing. But if you all want to consult with him at our next meeting or whatnot, you all can do that. But we have to do it within 30 days of today.
It might be beneficial for this is recorded and for him if he wants to listen to the public comment and hear what public comment is offered today, and then we can make a decision in a week or whatever afterwards. So it's good to give him some leeway in this.
Yep. I don't know if it's worthwhile me reading it or not. It is on the website, and we have it up here, although you can't see the whole thing at once. Yeah. I mean, I don't think it's worthwhile for me to read it. We've published it. So.
Okay, we'll open it up for public input on it. If you want to comment on it, if you'll come to the podium, give your name and address, and speak into the microphone. You're welcome to do so if you want to comment.
You think it's working? Okay. Hopefully it doesn't. MB McAfee, 22277 County Road 20, Duluth, Colorado. Well, as you know, Mr. Baxter, this statute has a list of the types of areas that can be named for areas of state interest with accompanying activities of state interest. Counties must choose only from the criteria as defined in the statute. The areas of state interest that counties can choose from are 4: mineral resource areas, natural hazard areas, historical, natural, and archaeological areas, key facility areas. So I would ask which of these areas you are choosing to use for this resolution. That's a question I have that I hope you can respond to. Secondly, only one activity of state interest can be chosen, and these activities are also specifically designed in the statute, or defined in the statute. Possible activities include site selection of a variety of projects, big projects like sewage treatment facilities and pipelines, solid waste disposal, airports, rapid transits, arterial highways, facilities of public utilities, new communities, municipal and industrial water projects, and nuclear detonations. Additionally, activities of state interest can include protection of historical or archaeological resources of statewide importance that have been identified and registered by the State Historic Society, or protection of natural resources of statewide importance, including significant wildlife habitat as identified by the Department of Wild Health. You can choose one of these activities. So there is not a category for recreation. This resolution designating Phil's World as an area of state interest and recreation as an activity of state interest is invalid. Plain and simple. The statute does not recognize recreation as an activity of state interest, nor Phil's World as an area of state interest. This entire action of using HB 1041 to protect Phil's World is a futile endeavor.
So do
Could
you
you
think I should
clarify the
answer?
Department of Wild Health? What was that?
Wildlife. If
Oh.
I said health, I misspoke.
So you're talking about Colorado Parks and Wildlife?
Yes. Protection of natural resources of statewide importance. This is straight from the statute. Including significant wildlife habitat as identified by the Division of Wildlife.
Oh.
And you're not doing that, though there is an eagle's nest in the area. But this is not being pursued your resolution is not pursuing protection of Phil's world as a way to protect
Let me ask
wildlife
you,
habitat.
since you've read that resolution so thoroughly, do you see in there anywhere where it prohibits recreation designation as a outdoor recreation activity? Is there in that statute where it prohibits that as a use?
Under this statute,
Yeah,
there's nothing that prohibits it,
so maybe
Mr.
it just
Urtel,
hasn't been tried.
but simply it says you must choose from one of the following. Of the first 4 I read, and the next, I think about 13 I read, one from each of those. So you must choose from one of those, which I would believe the law is implying very strongly that other areas of state interest or activities of state interest are prohibited.
And so you all know, I disagree with Ms. McAfee's interpretation of it. It certainly doesn't, and actually, part of that statutory scheme specifically says that no provision in this article shall be construed as prohibiting local government from adopting guidelines or regulations that are more stringent than requirements in the criteria listed. And so maybe we're blazing a new trail, who knows? If you read the first couple or I guess the second and third paragraph of the draft resolution, even if you were to agree with Ms. McAfee's interpretation and disagree with mine, like if I was to lose this in court, I think that we're actually covering enough areas that are listed in the statutory scheme. I mean, we say that we're preserving site selection and managing development of new communities. BOCC is going to consider the benefits of the current uses and activities. The next paragraph is the trail system is an important area of outdoor recreation activity and tourism, which I think is what Ms. McAfee objects to. It's also of important historical value and contains mineral resources. Mineral resources is obviously listed in there, historical value is listed in there, management of communities is listed in there. But if Ms. McAfee wants to challenge this in court, I think that what she would want to do is she'd want to try to develop there and go through our process. And if she satisfied the U.S. or state requirements, and we turned her down through our high impact permitting process, then she could take us to court on that, and we'd see who was right, whether or not we could in fact prohibit her. I'm not worried about those concerns, but it is true that it doesn't specifically list recreation. I think we're okay, and we'll see. As time plays out, whether or not we are or not. But that's how I think that this thing it could get shot down in court if we deny somebody development rights there, and we go to court over it. That's where we'll learn whether or not she's right.
Sustainable or not.
Yep.
I have no intent of suing you. I have no intent of developing. I do have the intent of saying to you that DOLA, upon whose funding you might depend for some development of Phil's world, is very interested whether or not you are making this a 1041 rule when it is by statute not one of the listings that is permitted by the statute. So funding in the future could be jeopardized by whatever action you take.
Thank you, MB. Is there anyone else?
Still one of these
Yeah, very good idea.
instead of, so you don't get this clock.
I'll see if I can do what she did. Well, she made it squawk. I'm Gayla Pock, 7672 County Road CC, Pleasant View. I have some of the same concerns that MB does. The resolution to protect Phil's world is certainly laudable, and I respect you for trying to do that. However, HB 1041 does not recognize recreation as an area or activity of state interest, and HB 1041 requires that to limit oil and gas development, COGCC has to concur, and I'm not aware that they have. I'm not aware that they're even aware that this is happening. So the resolution does not accomplish what it is attempting to accomplish. But there is in process a way to protect Phil's World from oil and gas development, and that's to have the owners of the land, BLM, owns part of it, I know the state owns part of it, declare this an area of no surface occupancy, and they can do that for the state as well as for their own land, I'm under the impression of, through the process called a master leasing plan. A master leasing plan can accomplish what this resolution cannot, but that you're attempting to do. So I'm encouraging you to support a master leasing plan that can protect Phil's World.
The BLM has not put any of the property in Phil's World up for lease, have they not?
I'm,
You bring in COGC, but I don't believe any of the land that's inside of Phil's World or pertains to Phil's World has ever been put up for lease, has it?
I'm not aware that it has. However, there is case law of an area not being upheld as an HB 1041 because to prevent oil and gas development because COGCC did not concur with that when it was originally done. Seems like it was Curtis. I can't remember the name. But there is some case law that says if you're going to restrict oil and gas, you do have to have a COGCC concur on that. And maybe they have they?
Couldn't tell you.
I don't
Since
think.
it's not leased land for mineral extraction, I doubt that COGCC has had anything at all to do with the land around Phil's World.
And they won't say anything at this time.
No,
It's,
there's no mineral extraction lease on that property.
but if somebody wants to lease it, that's when it will come up.
Sure.
Thanks.
Thank you, Kayla. Is there anyone else?
Oh, in the map, so the top of the map, we would need to change because it says proposed, and if you all adopted that, we would change it to just a more appropriate title, that these are the boundaries of what we're talking about. Any sort of development access routes are limited to what the access which is already allowed is there. So that just shows the area and also the routes that already exist.
Dexter Gill, Road 22, Lewis, Colorado. I'm all for the county obtaining and maintaining control over the lands within the county. This is one vehicle to do so. With that said, also, it's difficult for me to enjoy having our lands tied up for potential future uses and developments that we're not aware of today. And the idea of locking in a particular use would remain difficult to change in the future. It's kind of like a wilderness area. They say, well, you can always change those. It's very difficult to change them. So I hate to see something locked up today that we don't know what the future holds. So we have the problem, as I see it, is the BLM lands have not been complying with their responsibility of coordinating, and if a leasee comes up with a project, they are supposed to coordinate with you guys, with the county. And your input and decision should be recognized by the BLM. They're not free to do as they choose, which has been in the past, unfortunately. But we should amplify and enforce the actions of the BLM and Forest Service, any of the federal agencies, that any proposal has to be before this body, for the county. You could easily identify Phil's World as in our county management, land management planning, as a preferred use at this time. And if any other proposal comes up, it would have to be coordinated with the preferred use that you've identified at this time. Not locked up, but it may change and different opportunities may come up before us. So enforcing the existing laws that the BLM and Forest Service needs to comply with can maintain the adequate preservation of the recreational use of this land, and also make other needful management needs out there. We may need to clean out a lot of fuel wood areas to keep it from burning up. That needs to be able to adequately take place on a quick management decisions, not have to go through a restricted procedure like this may inhibit us. So we are all for limiting the gaining control of the lands. We need to not tie our hands up for future uses, but yet allow the beneficial use of our recreational use at this time. Thank you.
Thank you, Dexter.
If I could just follow that up too, real quick before anybody else is, we can't lock it up. We're not allowed to do that. It's not our land. We can't prohibit oil and gas development. We can't prohibit a number of things on there. What this hopefully does, in my opinion, is to give the county a say on land that's not ours that we otherwise would not have a say on. You can't actually lock it up, but without exercising, your rights under this, then you don't have a say. It's the BLM or the state. And so what this does is makes anybody also have to come through you all for approval.
Anybody else? One more time. Anybody else? Okay, we'll close the public hearing. I've talked to John, and Keen and I just talked a little bit ago. I think what we'll do is delay vote on this until we have the full commission here next week. If you would put it on the